Good afternoon. My name is Debbie Moore with Advisors with Purpose, and I'd like to welcome you to today's webinar covering key reasons to review your will. We have about 20 minutes set aside for this topic, and then we'll leave some room at the end to answer any questions you post during the webinar. I'm recording today's session, so in the next few days, you'll receive an email with a link to the recording for you to be able to review the presentation again or share with your loved ones. So it is now my pleasure to introduce our presenter, Aaron Rustin. Aaron is the president of Purpose Financial Corporation. Aaron brings with him significant experience in the financial world. In addition to his private practice, Aaron recently joined our team of professionals at Advisors with Purpose, helping God's people manage God's assets to advance God's kingdom. So let's get started. Aaron, over to you.
Thank you so much, Debbie. It's an honor to be involved with Advisors with Purpose. And I'd like to welcome everyone that's on here right now to our second in a series of webinars, topics of interest, which we hope will assist you in making solid, informed decisions when dealing with your financial planning and estate needs as we move forward. So again, thank you so much for being here. We're going to touch on some matters that affect each one of us. And that is, of course, when we no longer require what we have, how do we pass these things on to our loved ones, on to charity and those in the future? And more importantly, even on top of that, is making sure that what we're doing is up to date and really meeting our needs. So, says that death and taxes are said to be the only things guaranteed in this lifetime. Well, that old adage is actually wrong, because if you think about it, change is a certainty as well. Our lives change every day, and our planning must adapt to that change. Just as maybe the color of the clothing we like changes on a day-to-day basis, or even in my daughter's life every hour or so, I think it was. There are changes that come about, and we have to stay on top of things. So it comes down to really how do you see things? Is this kind of your attitude when it comes to someone taking care of your needs for you? I'm of the view that my beneficiaries will receive too much from me already. So I direct the cost of any application to court come out of my estate, of course depleting it. If after any argument my next of kin can't agree on someone to be administrator of my estate, I direct the court to name a stranger in the public trustee's office or a trust company who could act in that capacity. Well, of course, this is kind of tongue-in-cheek, so to speak, because of course what happens here is suddenly you're giving it into somebody's hands who doesn't know what you need. And you know the thing is, and you're going to see as we go through here, everyone in Canada has a will. Now you might think, well, you know what, that's not what I heard. Well, actually everyone in Canada has a will. It's just 55% of those are going to be decided by the courts. So who's going to take care of your needs? Who's going to take care when you can't for what you wanted to see happen? So for instance, a personal or a medical directive. This may be your opinion. I'd rather have my next of kin worry about making the right decisions for me and second guess what I would want. If they feel guilty about any such decision, especially if they stand to gain as beneficiaries, so be it. It'll make them think about me more often. Now, isn't that ironic? I honestly think that some people might even be thinking that. And the unfortunate part is the only ones that get hurt in that are those that, of course, are doing up the wills and those that we had wanted to receive them down the road. Now, where there is a will, there is your way. I've said that for a long, long time. But is your will really speaking to your wishes? Is it really letting the world and your loved ones and charity know what you wanted to have happen when you no longer had any control over it? So, key reasons to review your will. Now, there are many, many, many. We could fill up a couple of hours on reasons. But these were some of the things that we brought together here just to say, you know what? Stay on top of these things because they can make a big, big difference. So, new children or grandchildren, number one. New children or grandchildren, friends, relatives, or pets enter the picture. If a will outlines, understand this, if a will outlines that a person's estate is to be divided equally among his or her children, even children born after the document is signed will be included. However, that all being said, it pays to take a look at the document just to make sure it is worded in the correct manner. And you'll notice I have one last little thing, or pets. It's actually now a thing that more and more people we see in the design of what we're putting together, that people are making provision for a little Tuffy or Buffy or Squirt or whatever you call your dog or cat or parakeet to be taken care of after you pass away. These animals have become part of the family. And I think it's wonderful on a number of fronts that people want to make sure that those animals, those close furry relatives that brought them such comfort during their life, are actually taken care of at the other end as well. Change in personal health and lifestyle. Number 2, make sure you consider the amounts you are promising to benefactors and allow for the possible depletion in the value of assets if care is required due to injury or illness. Now, what I'm saying in that is we may make all the promises under the sun, but what would happen if something happened to you and I, and suddenly our estate was depleted considerably because we required special help, whether for injury or illness or whatever that might be. In a survey taken by Genworth Financial's Cost of Care survey, it was shown that on average, assisted living facility is about $3,450 a month. Now that might be considerably higher in Vancouver or Toronto, but overall that's what it is. So look to those factors as well and make provision. What if you move? What if life's journey takes you to a completely different province or even a different country? Now, provinces may have different ways with which they treat property and assets. If you move from one jurisdiction to another, you'll want to ensure legal wordings will meet your desires. Understand, it only takes one outdated, misplaced, or misinterpreted word to change outcomes. Now, also understand, if you happen to have properties in different provinces or different jurisdictions, there may even be different manners in which they're treated from a probate perspective. So understand those things. A property in Ontario or BC, you may get considerably higher charges as far as probate than you would say living in Alberta or having that property in Alberta. So make sure that you're always checking up on things if you move. Number 4, you've come into money. An inheritance, we'll say a money, home, land, or whatever. Business success, suddenly your company, that little fledgling company that you start out, now has 50 franchises, or you've invented something that has taken the value of your company through the roof. Gain on the stock market. Over the last little bit here, we haven't seen many of those with the markets bouncing around quite a bit. Sale of assets. Again, maybe selling a home or land or your company. Or maybe you've just simply stopped drinking expensive coffee-flavored drinks that I won't mention the coffee places like Starbucks or Tim Hortons. I guess too late to mention them. So all of these things can increase the amount of net worth that you have. Such moves upward in the value of your estate and what you have can indeed change the way that you wanted to allocate those very assets. So remember, talk to a professional advisor to ensure proper structure implemented at all times. Change of marital status. Now, divorce, and you can see from the statistics that I have, 50% of first marriages end in divorce, 67% of second, and actually astonishing and yet maybe not, 74% of third marriages end in divorce. Now, most people don't want to leave money or certain rights to an ex upon their death or risk that he or she will contest the document. If married spouses do not execute new wills after separation, then effectively the old wills are still valid. So remember that. Your previous will isn't rendered ineffective until you're actually divorced, and possibly only partially then, depending. Again, this is why legal and professional advice is so important. When you die after getting legally divorced, your will treats your spouse as having predeceased you. Okay, so you know what I find too, it doesn't hurt to do a little bit of checking. There are some amazing resources now on the internet. Make sure they're a dependable source. Just do a little research. And these are things that Advisors with Purpose advisors are going to help you out with. If you're required to talk to one of us, they would love to help you walk through these things. If divorced since you last signed a will, consider discussing with an attorney what changes you might require. In the case of a new marriage, now, in most provinces, a new marriage invalidates an existing will. So the old will no longer exists. If a new will is not made, laws of intestacy may determine how assets are distributed. Now, intestacy, if you weren't on the last session, actually speaks to that person that has never put a will together, which means then the distribution of your estate is regulated usually by court-appointed rules in the province in which you live. Not a good thing, and chances are they may not distribute things the way that you had wanted to. If making a new will prior to a marriage, ensure it is understood the will is being made in anticipation of marriage. So notice it says prior to a marriage. Make sure that the will clearly states it's in anticipation of a marriage in case for some reason it doesn't quite go the way that you had wanted it to, and you may need to make some changes. There are different laws across the country, and this is why it is so very important to have professional advice at all times. Best to get a new will and review beneficiary designations upon marriage or any change in marital status. Key components that if you don't get them checked out, you might find, again, assets being distributed in ways in which you did not want that to happen. Disposition of estate, bequest to spouse. Now, I hear, unfortunately, attitude things like this every now and then. I don't care how large my estate may be. I think my spouse should learn the hard realities of life. Interesting. Accordingly, I give my spouse only $40,000 and 1/3 of my estate. I got a feeling if that's the person's attitude, I think the spouse already learned some of the hard realities of life going through life with a person with that attitude. It remembers again, not only has this attitudinal issues wound throughout it, but such wordings could bring about numerous issues and challenges with the way the courts can distribute an estate if you don't have a will in place, a current, up-to-date will. Your spouse passes away. Number 6, your spouse passes away. If your spouse were to predecease you, you'll want your assets to go to a different relative, friend, charity, or benefactor. You want to make sure, because again, if your spouse has predeceased you and you have not made any changes, your will is kind of set out there in a state of limbo, in a way, or effectively it looks like you have no will, and again, the courts could actually be distributing according to the rules of the province or the jurisdiction in which you live. You may now feel differently about things and want to distribute your assets in an alternate manner. Your wife and you may have had, or your husband and you may have had different things that you supported. Now that that partner is gone, perhaps you're looking at life a little differently. Certain holdings such as RSPs and RIP accounts or various capital assets will now be potentially subject to significant tax ramifications at your passing. So proper planning is required. So again, even tax matters should be addressed through your will in a roundabout way and tie together with your overall financial planning. And again, the advisors at Advisors with Purpose can help you walk through some of these things and direct you to a good legal representative of your choosing that you feel would be able to help you out. Number 7, you've had a change of heart. Many people draft their wills when they are first married or when young. That is true, certainly. Unfortunately, a lot of young people don't think they actually need it because they say, well, we don't have anything, blah, 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 and all that. Well, from the moment you have an asset or you've taken someone else on as a partner, you do have obligations, and I believe you should have a will. What seemed appealing when you were young may not work when you're older. Maybe you wanted to give a whole bunch of money to a charity that built widgets. Well, widgets aren't really around very much other than in southern parts of Saskatchewan. So you know what? You may want to put your money elsewhere. Example, a special car to your children, or not. One of the children is suddenly showing an interest in a car, antique collections, maybe even things like an old sweater or other personal items. You know, I've actually seen families get into quite the fights over things such as even an old Singer sewing machine or a sweater or a little necklace. If only someone had clearly stated who was to get what, it would have saved a lot of pressure and unfortunate circumstance, I believe. Your number 8, you account for charitable giving. Some individuals become connected to certain charities, organizations, such as church, charity, or cause. The proper updating of a will can actually make sure that you can continuously update where your heart is leading at that point. This can bring about considerable tax advantages if coordinated with other planning pertaining to that point in your life. So understand too, once you put a charity or the like within your will, you can change it. It is not carved in stone. You can change over time. And never assume your family will distribute your assets as you would have. I've had people say to me, well, the kids know what we would like to give to, and they'll do it. Well, let's not leave it to the benefit of the doubt. Or let's give it the benefit of the doubt, I should say, and just you dictate. You say where things are to go and let your executive distribute. Philanthropic bequests, or don't bother with a plan at all. I'd rather donate a large portion of my estate without tax deduction or savings to the CRA, since I'm sure my money will be better used by the federal and provincial governments. Of course, another little tongue-in-cheek thing there, but again, I reiterate, remember, 100% of Canadians have a will. It's just that 55% of those will be decided by the courts, not the route you want to go. Number 9, implementation of trusts or other planning structures. As your assets and estate values rise, more structured, detailed plans may be required to maximize value of estate while mitigating the negative impact of taxation, probate, and other estate depleting factors. Examples such as trusts or charitable flow-throughs or estate bonds can save your estate considerable amounts of tax and can actually give more to your family overall rather than having money automatically directed to Canada Revenue Agency. Can't decide what or how much to give to whom? What if personal wealth position changes? We talked about suddenly having a windfall in value. Well, after determining the most efficient assets to pass to which benefactor, consider leaving units or percentage of residual estate to beneficiaries rather than specific items or amounts. Maintains equality of bequest to all parties, does not leave some with significantly less due to priority treatment of certain bequests. Now, example, 40 years ago, your estate was worth $100,000. You had a fixed donation of $10,000 to charity, then 10%. Now, your estate is worth $3 million. $10,000 is not as significant. However, 10% would be $300,000. This works the other way too. Let's say your estate is now worth $5,000 and you had set up a $10,000 gift, which was to be distributed prior to your family or whatever. Your family may not get anything. Things to consider. Choose a reputable, experienced source to draft documents. Example, the law firm of Dewey, Cheatham, and Howe. Probably not a wide choice. Just feels kind of awkward. I don't know. Look and press for quality service with references. Always check what kind of work would they done before. Your will is your last statement. What do you want everyone to hear? Remember, you do have a choice. Proper and current planning not only maximizes what you have to work with today, but can maximize what you are able to leave to loved ones and charity when you no longer have need of it. Summary, review your will and other important documents, enduring power of attorney, medical directive on a regular basis. Recommended at least every 5 years, have a look at it. Your entire will does not always need to be changed or rewritten. Paragraphs can be changed to meet new wishes by way of a codicil or a transference of paragraph, a new paragraph put in. Restructuring of will does not need to be highly expensive. It is recommended you research competent legal representation pricing options. Will kits can be okay in some cases. However, I recommend a full legal review to assure proper structure with appropriate and pertinent current wordings. A current and properly structured will can save your estate considerable amounts of money, as well as remove elevated stress in the settling of your estate matters. Remember, just as life changes, so should how your wishes are presented to those that will be here when you're left. So seek professional advice. The preceding was provided for information purposes only, not to be considered a legal opinion on matters concerning your individual situation. All matters should always be discussed with your professional advisor. Back to you, Debbie.
Wow, Aaron, that's a lot of information. So thank you for this wonderful information. So where do we go from here? Something Aaron said may have triggered a question, or you may want to know more about the process, or this is maybe exactly what you've been looking for. So in the next few days, you'll receive an email from Tanya Rust, and it actually appears in your email as trust at Advisors with Purpose. The invitation for you will be given to you to have your own personal consultation with one of our estate advisors. So all meetings are done on the phone. You don't have to leave the house to speak with the advisor. They're completely confidential. The advisor will never sell you any product, and the whole process is free. I would encourage you to take advantage of this opportunity. So we did have a couple of questions that came in during the webinar, Aaron.
Okay.
First one is, it says, if I have included my child and their spouse in my will, but they get a divorce, do I need to change my will, or will their divorce fix it?
Well, no, because it would it would change their will, but it wouldn't change your will. So I would, those are things in which I would make sure, I would take it to a legal representation, have it gone through, because what I would suggest to any of our clients would go and get that second name removed from there, or that second allocation. Again, just to make sure. I'm sure that might be removed just due to their divorce, but I never take any chances with that type of stuff. So I definitely seek legal opinion on that.
Perfect. So then the other question is, what's the average cost for a will? Are power of attorney, property and personal also wise to get done at the same time?
Yes, definitely. And remember too, when you're getting a will, power of attorney, make sure that it's called an enduring power of attorney. Different provinces have different names for it. A normal power of attorney, when it is set up, and it's so ironic with it, if a person becomes mentally incapacitated, it can actually nullify a power of attorney. So an enduring power of attorney, or whatever it may be called in the individual provinces, will make sure whether you're physically or mentally incapacitated, that person or persons that you've designated can truly act on your behalf. As far as costs, the other day, it was so strange. A person came in here and they had a will done up just a little while ago, and they quoted me a price that they had a will and power of attorney medical directive done up, and it just about knocked me right out of my chair. I know my wife and I have fairly more complex structures, I guess, because of our personal as well as corporate holdings. We had our wills, power of attorney, medical directives, and all of those things redone about 3 years ago. And I believe the total cost was just over $500. And it was a little bit more complex. And we worked it to tie in with our corporate shareholder agreements and stuff. I've heard some into the couples of thousands, and I don't know. I would definitely look around though. Check on rates. Make sure the people that you are checking with, the law firms, have a good understanding of doing wills. Just because you're a lawyer does not mean that you understand fully how to structure a will. Just because you'll sell life insurance doesn't mean you definitely know how to do financial plans. So same type of stuff. So that's what I would recommend.
Great, thank you very much. So again, you'll hear from Tanya at Advisors with Purpose in the next few days with an invitation to speak to one of our advisors. It's a good experience. I think you'll find it worth your time. So I appreciate your help, Aaron, and all your information. And just thank everyone for joining the call today.
Thank you so much.
Thank you so much.